into today's news topic. I just wanted to go over a few questions or points of confusion I saw in assignment 2. I have hopes, by the way, of getting you back your graded assignment 2s later this week, hopefully Thursday. But there are a couple of areas where I saw a number of people had the same area of confusion, so when that happens, I like to go over just to see if I can help clarify. And the first area, which is easy to fall into, is one of the bigger dangers of online searching. Many of you, when you write your evaluations, really like online searching and better than print because, and you give a lot of good reasons. And there definitely is reason to prefer online, but one of the dangers you need to be very careful of is because you are doing keyword searching and the computer is stupid. So the computer, remember, doesn't know what your issue is or what your area of law is or what your context is. It's going to pull up sections with your terms that don't have anything to do with your subject. So here's an example, and check this out, false statements, right? So if you just see false statements, you think, ooh, that's really relevant for our client. But it's false statements regarding mileage registering devices. And depending on how you looked at it, it's possible if you were looking at the table of contents, Westlaw cut it off on you, so you just saw false statements and you thought, ooh, that sounds relevant. So the moral of this story, especially for when you're looking at statutes, but actually any secondary sources also, is be very aware of context. In the statutory realm, we sometimes call that statutory scheme. If that makes sense to you, great. If it doesn't make sense to you, don't worry about it. But think about where your context. Are you looking at the right area of law? So, for instance, this is even a little bit confusing because Article 26, miscellaneous, that could mean anything, right? That's not very helpful. Sometimes the article will clue you in. So if it's an article about, say, farm products, another area in New York law in the agricultural markets title, if it's about farm products, you can look up and say, oh, farm products, tea really isn't a farm product, so that's not going to be relevant for me. But if it's miscellaneous, then you have to dig a little deeper and maybe even have to read the first couple of sentences to realize that this whole section does, in fact, apply to registering devices, motor vehicle registering devices. Related, a number of you cited to a New York Penal Code statute as your best section, and it was a penal code on false advertising. Again, the words, very relevant. And yeah, sure, you're all law students, so at least a couple of you are going to argue, well, we want to make sure our client doesn't get charged criminally for false advertising. And yeah, that's kind of true in terms of course, you don't want your client to be charged criminally, but what your client's really worrying about, she's not going down trying to do she's trying to be as careful as she can and avoid that in the first place. So while, yeah, you might want to be aware of that, really the better sections are going to be some of the other sections within the code that most of you found, in fact, regarding false advertising. Which brings me to my next point, and that is, again, a danger of keyword searching that some of you actually picked up on when you used the print index, and that is this hypothetical works very well for my purposes in terms of teaching legal research because it covers a couple of different areas of the code. So some of you found agricultural market sections in New York. Some of you found general business sections in New York. Some of you found both. And as it turns out, sections in both titles are relevant. And depending on the search terms you use, you might pull up just one or just the other. So again, you want to be aware of the limitations of the searching, which brings me to my third or fourth point. I've lost count, it doesn't matter. And that is do more than one search. Some of your evaluations, and I couldn't quite tell what you were thinking, but based on what you wrote, some of your evaluations suggested that if I only have to do one search, that makes it a better source. And sure, easier is good, but don't prefer easier over relevance and quality. You probably want to do a couple of searches. I mean, if it's a very simple issue and it's a quick and dirty search and, you know, you're pretty confident, that's one thing. But if it's something you really don't know a whole lot about, you want to try a few different terms because maybe false advertising doesn't pull up everything about misbranding. Or maybe misbranding doesn't pull up everything about false advertising. If you only go with one of those terms, you're risking missing out on relevant sections. And that was true in the federal code as well. There were two different titles that were relevant, and depending on which words you used, resulted in coming up with different titles. And some of you did observe that when you used the print index, because it was a human being sitting down and thinking, knowing that misbranding and false advertising are kind of related, it directed you to both titles. Okay. Other point, when I asked you about comparing your secondary results from the first assignment to this, and I could see where the wording of the question might lead you in this direction, so it's fine, but more importantly, from a strategy standpoint, you want to use both. It's not an either-or question. Secondary sources may not lead you to all the relevant sections, and several of you pointed out, hey, secondary only led me to this relevant section, but meanwhile, when I did my statutory search, I found this other relevant section. And to that I say, good, then secondary served its purpose. It got you started, and a lot of you recognize that. Secondary sources rarely are going to give you the entire answer. That's why we spend a lot of time talking about researching primary sources. And the other aspect that a few people mentioned that, again, I could see where the structure of the assignment led you to that conclusion. You don't necessarily always have to do plain language searching and terms and connectors searching. In fact, my preference, because sometimes I can be lazy, I admit, is I'll do the plain language because, yeah, it's easier. But if plain language isn't giving me relevant results, then I'm going to sit down and think about how best to structure my terms and connectors, and which connectors to use, and which alternate terminology to use when I do false advertising or misbranding, and go through /s and go through that whole thing. And when /s doesn't work, change it to /p and go through that whole analysis. Again, the idea of presenting this to you and then having you practice it on the assignment is to give you those tools in the toolbox. Plain language searching is great when it works, and just between you, me, and the lamppost, I suppose I shouldn't say this when I'm being recorded, and that is that I think the Westlaw plain language is far superior to the Lexis plain language. Now, there are things about Lexis I like better also, but so understand that plain language searching won't necessarily always give you a great answer, and there are weaknesses in some systems, or maybe all systems, depending on the issue. Okay, any questions about all of that? So we move from the complex area of legislative history, finally, to the area that you're probably more comfortable, if not most comfortable with, and that is cases. Because, of course, you've been talking about cases since your very first day of law school, I should guess. So we are going to review some of the more advanced techniques, but I'm going to take a step back and go way back to possibly even that very first day of law school, certainly the first month, and talk a little bit about stare decisis. So taking that step back, and again, I realize that you all mastered this in first year, so this is indeed a review. So back to our sources of the law handout. So we've talked about the legislative branch. We'll talk about the executive branch in just a couple of weeks. Let's talk about the judicial branch. And of course, we have standard 3 levels of the courts. You're all, I'm sure, familiar with this. What starts to get interesting and is relevant for research purposes is that, of course, it's not this simple. So we've got the basic trial level to the appellate level to the highest level of The system, oddly enough, in New York, the lowest is Supreme Court and the highest is Court of Appeals. If somebody knows why they came up with those confusing names, let me know. And again, I think also as sort of a little mini theme of mine is in part in understanding research, is just understanding the abbreviations. How many people are familiar with the MISC abbreviation, just for my own curiosity? Everybody know MISC? Sort of. So MISC stands for Miscellaneous Reports. That's one of the official New York reporters. So if you run across that, you would want to know that, because then you would know that's the trial court. So understanding the abbreviations can help you place the case in its proper level of hierarchy. Okay. So let's take a look at the walkthrough handout, and it is on, the PDF is on the TWEN site under the Cases Handouts link for those who want to follow along on their laptop rather than in paper. And I'm going back to the textbook that possibly some of you used in first year, Legal Reasoning and Legal Writing, borrowed partially by our very own Professor Newman. Yeah, brings back good memories, right? What's that?
First book we ever opened, everything comes full circle.
Yeah, imagine that. There's something, I like stories that come full circle, so I'm glad to be part of that. So you've all seen this, turning to page 2. And of course, the types of authority, we talked about primary and secondary, and I don't need to go over that. But what I liked about the chart under the primary authority is that one phrase that you're looking at primary authority that governs the court in which your lawsuit will be decided. And for me, that crystallizes what you need to think about as you're looking at a case and thinking, is this case controlling? Is it authority for my particular situation for where I am? The court in which your lawsuit will be decided. So getting into a little more depth in that concept, turning to page 3. So I've underlined, highlighted the phrases that I think are useful. So of course, only bound by decisions from higher courts within the jurisdiction. So if we take a look at page 8 of the handout, which I will also on the screen. So here in New York, you can see a basic illustration of the structure. And on page 9, you see a little more detail of that structure with what the different courts actually do. Now I'm going to focus in New York, but if you are interested, and you may be interested to wind up practicing in another state, I know several of you are thinking of that, or you wind up being involved in litigation in another state, which is certainly possible too. You want to understand that state's court structure. Believe it or not, the Blue Book is actually pretty good for giving you an explanation. I know some of you are good friends with your Blue Book, so those tables at the end with the different jurisdictions will give you a sense of the different courts in different states. And of course, different states have their own legal research guides, so that would be another place to look. So here in New York, of course, it gives us this, again, the basic structure we can see here. So back on page 3, oh, and I should mention federal too, because obviously you might be involved in federal litigation. And that map you can see on page 15, or a slightly different color scheme here on the screen. And again, the different circuits, so telling you which. So obviously, practice in New York, you worry about the Second Circuit. Those of you going to New Jersey, the Third Circuit, California, the Ninth, and you probably already knew all that. So necessary to keep in mind. So continuing back on page 3, thinking about, again, authority. There's also the interplay between state and federal, and of course you talked about the Erie Doctrine at length in civil procedure, and I am certainly not going to try to repeat that. But keep in mind, again, that where a state court decision might actually bind a federal court, and it describes it here. And then it goes on to say some states are divided into more than one appellate jurisdiction, like here in New York. In that case, the intermediate appellate court might bind only those trial courts in its jurisdiction or all trial courts in the state. So here in New York, we have 4 different appellate jurisdictions, so let's keep that in mind. We will investigate New York in just a moment, but again, I want to step back just to think overall about authority. Again, I'm sure you talked about this in first year, but just to place it in a research context. Turning to page 4, and this actually goes back to that chart we first looked at on page 2. So, of course, the Constitution prevails over an inconsistent statutes, and this is just the underlying passage on page 4. And either Constitution or statute prevails over inconsistent case law. So as you start to research case law, you've got inconsistent, and then you've got a statute saying something else, the statute will prevail. As well as the statute will prevail, court rules, administrative regulations, agency decisions, which we'll be talking about in the next few weeks. And so again, the statutes trump the common law, except, of course, if a case finds a statute unconstitutional. So it also talks about here how newer statutes will trump any prior inconsistent statute, regulation, or decision. So again, that concept of something that is more recent is going to have more authority. And then within the same jurisdiction, a decision from a higher court outranks a decision from a lower court. Of course, we know that if the higher court has the power to reverse the decision of the lower court. And that goes back to that very first concept that I read to you regarding if your matter can be appealed to a particular court. So that's what we need to focus on. And again, within the same jurisdiction, if a higher court rules it's one of its own prior cases, or decides in a way that's inconsistent with a prior decision, the prior decision is no longer valid. So again, that concept of recency having more authority. Okay, so we have a few basic concepts on authority, the concept of recency, the concept of the hierarchy of constitution statutes, and then within case law, higher courts. So the question then becomes, what's the higher court in your jurisdiction and what applies to you? And as it turns out, in New York, as is usual, life is pretty complex. For those of you going elsewhere, Jersey, I think, did somebody say Massachusetts? Was it you, Michelle? Yeah, okay. So Jersey, Massachusetts, it might be a little bit simpler. California, probably not so simple. So here in New York, if you take a look on page 6, we are now moving away from your first year textbook, for those of you who used it, and we're moving into the New York Legal Research Guide. So again, those legal research guides can be helpful. And we're doing that because, honestly, I found this to be the best explanation that I encountered for New York. And what we discover is that there are actually a couple of different levels of trial courts. There's the superior trial courts here in New York and inferior trial courts in New York. And the superior trial courts, the Supreme Court, and you can see the list there, will get appealed to the appellate division. And the inferior trial courts will get appealed to the appellate term. This is really complex. I'm oversimplifying, and I'm not going to be able to make it make sense, certainly not in the time that we have. So I'm presenting to you a concept that you need to keep in mind. What court am I in, and what court would my case get appealed to? And to me, in New York, the key to that is, what department am I in? So let's take a look at keeping track of that, and it's actually fairly simple. This chart that I'm putting up on the screen is actually on page 11. And whether you get appealed to the appellate term or the appellate division, you want to keep track of what department you're in, whether that appellate term's in the first department, for those of you who practice and or live in the Bronx or Manhattan, those of us in the second department, Nassau, Kings, otherwise known as Brooklyn and Queens, in there somewhere, and then what those of us who grew up on Long Island call upstate, the third and fourth departments, and if you tell that to someone upstate, they get a little perturbed, so don't do that. And for those of you who are from quote-unquote upstate, apologies. I grew up on Long Island. Anyway, so you can see the long list in the 3rd and 4th departments of the counties and areas that are comprised of those departments. So that, in essence, is the authority you want to think about. So when you are looking at cases in New York, you want to think, especially if you are looking at appellate division cases, you want to think about what appellate division is that from and what appellate division am I in? So if I'm in the 2nd department, as we are currently, and I'm looking at a 3rd department appellate division case, is that authority? So turning the page, actually, you have to jump ahead. There's no way to arrange, that's a problem with paper. There's no way to arrange it to get it all in the right order, so you have to go back and forth. So jumping ahead to page 12, which the page number was cut off, so if you look and find page 13, you'll obviously be able to find page 12. I'm now jumping to New York jurisprudence. And I'm jumping to New York jurisprudence again because it's a nice, simple, understandable to me explanation. I would, of course, never cite to New York jurisprudence if I am writing a memo or, heaven forbid, a brief. But what I would do is look at New York jurisprudence, look to the cases that it's citing to, look at those cases, and then read those and then cite to them if I think that that's appropriate. But for our purposes, let's turn to page 13, where I've highlighted when a question has not yet been decided by the appellate courts in a certain department, inferior courts in that department. So if I'm in the Supreme Court in the 2nd department, and there hasn't been an issue, and the issue hasn't been decided in the 2nd department, so the inferior courts in that department must follow the determination of the appellate courts in any other department until such time as their own appellate tribunals or court of appeals passes upon the question. So if I'm in the 2nd department and I'm in a trial court, if the appellate division 2nd department has decided, I got to follow it. Obviously, if the court of appeals in New York has decided, I got to follow it. But if I'm in a trial court in the 2nd department and only the 3rd department in the appellate division and not the 2nd department, I got to follow that as well. If there's a conflict, if there are 2 departments and Department 2 said one thing and Department 3 said the other, if I'm in the 2nd department, I, of course, follow Department 2. That actually is what happened. I don't know if you remember the Chase Scientific case that we looked at very briefly when we talked about legislative history, because my enterprising associate found the legislative history and made the winning argument in that case. It was actually a case about the statute of limitations where the 2nd department said one thing and the 3rd department said another, and the Chase Scientific case was actually went to the Court of Appeals to resolve the conflict between the 2 departments. So until the Court of Appeals decided that, I was in the 2nd department, I had to follow what that 2nd department case said. If I was in the 3rd department, I'd follow a totally different result, depending on what that 3rd department court said. As I said, complex area, I am vastly oversimplifying. So what you need to keep in mind in New York is what department am I in. Any questions? Okay, so let's move on to publication. And publication is relevant for a variety of reasons. First of which is that most people do not realize that most cases that come before a court, especially a trial court, do not result in a written, published opinion. Sometimes they don't even result in a written opinion. That's unpublished. And you want to keep in mind, again, for authority and citing purposes, the difference between published and unpublished. Has anybody encountered or thought about published versus unpublished before? Get a sense of... Okay, so yeah, some of you at least have a sense. Okay, so we will take a look at both. So I saw a number once that fewer than 10% of cases actually wind up being published. Don't quote me on the number, please, but just to give you a sense of just how few cases that actually wind up in a court wind up being published and possible authority. In fact, one of the handouts you picked up has to do with federal courts, but this New York Times article from a couple of years back actually refers to courts of appeals. So the appellate level of the federal system, and talks about how judges are typically the ones to decide whether a case is published, and therefore possible authority versus unpublished, possibly not authority. And the article talks about, I'm not going to go into great detail, about how some of the appellate judges in the federal system actually choose not to have their cases published so they don't have to be quite as careful in their drafting of the opinion. So just to let you know that this is actually a relative issue today. So what am I talking about, published or unpublished? As I said, a judge issues a decision. He or she writes the decision and then determines, is this going to be officially published and published in one of the official reporters? Again, back in our sources handout, you get a sense of some of those reporters in New York and federal. Or is it going to be unpublished? And just to make sure I haven't missed anything. So an example of an unpublished case. Basically, a judge issues an opinion but determines that this is not going to be published in an official reporter. What it will look like online, which is where you will find these unpublished cases mostly, and I'll explain that mostly in a moment. Here on Westlaw, basically, you don't see a citation to one of those reporters. So, of course, in the federal world, the reporters, FSUP, FSecond, SCT, the U.S., the other Supreme Court reporters, basically all you see is a Westlaw site. So when you see a Westlaw or a Lexis site, with just numbers that is not very super recent, you know it's unpublished. And even now, Westlaw and Lexis have learned that people can get confused, even lawyers. So it says only the Westlaw citation is currently available. What Lexis actually does for us, which I kind of like. And again, what you see here is Lexis. It's an older case, so 2011, I think. You do see, now this is my mostly point, you do see a citation to a reporter, Fed Appendix, APPX. Federal Appendix is basically, in my humble opinion, a means for the publisher West to make more money. So what West did is they took these unpublished opinions and they just put them in a book. So they're not published in the formal sense of the word in terms of citable, but they are in a book called Federal Appendix. And you'll notice here on Lexis, and this is, I said there are reasons that I like Lexis better, and this is one of them. Lexis gives you a heads up. Notice, please refer to the Federal Rules of Appellate Procedure governing the citation to unpublished opinions. This is why understanding published versus unpublished matters. Depending on where you are, you may or may not be permitted by the rules to cite to unpublished opinions. Actually, I believe since 2007 you are permitted to cite to federal unpublished opinions, but they would not be considered authority. Pre-2007, I think you have to check the particular circuit court rules. And for those of you who really like to keep track, take a look at Federal Rules of Appellate Procedure 32.1. I've now told you everything I know about that. So if you want to investigate it further, go for it. On the state level, here is a chart, and this link, again, is on your course website under class web links. It's a little old. It actually doesn't tell you the year on that. It took me some digging to figure out that this chart was put together by this librarian back in 2007. But it gives you at least a start of what to look for in your particular state in terms of whether unpublished opinions are citable. So you want to think about that when you are looking at unpublished opinions, and when you're looking at any opinion, you want to figure out is this published or not published. So again, if you only see that Lexis or Westlaw site and it's an older case, it's unpublished. What a newer case looks like. So here we see what happens is when cases first come out, they just haven't, and it is published. When it's super new, they just haven't figured out what exactly the citation is yet. So what you might see Sometimes you won't be able to tell. So February 21, that's still pretty current in the case publishing sense of the word current. So sometimes you'll see the word slip opinion or slip copy. That is from the old days of print when cases were published individually and they were about this size and you'd see the case and then you just turn the pages and they got sent all over to libraries and libraries struggled to keep track of these teeny weeny little thin cases. I don't know that too many courts do that in print anymore, but they still for some reason refer to the term slip copy or slip opinion. So that's why I'm telling you. And so you can see right here on Westlaw. So this particular United States District Court of New Jersey case. Only the Westlaw citation currently available. We don't know if this is going to be published or not, so that's a little bit uncertain. For the current case, let's go back. So you can see another one. Here's another example. So this one likely will be published because it's got an FSUP site. We just don't know the volume and page yet. Again, because it's pretty recent. A month ago. Less than a month ago. So two situations where you're going to see just that Lexis or Westlaw site. One is very recent, which is going to be kind of obvious, within a couple of months of today. The other, if it's not within a couple of months of today, you can pretty much be confident that it is unpublished. And on Lexis, it'll even warn you, which again is one reason I like Lexis. Okay, any questions about publication, published, non-published? So here in New York, there's an official New York website called the New York State Law Reporting Bureau, as you can see up here. And it talks about how opinions are selected for publications. If you are interested in that for New York, you can learn that here. So in the old print days, just to give you a sense of terminology, should you run into a supervisor, an attorney who still uses the old terminology, you'll know what they're talking about. So I already told you about slip opinion. Slip opinions then got put into something called an advance sheet or advance reporter. They tend to be soft-bound interim print publications, and then of course they would get published in the final bound volumes, many of which we still have in the library, but more and more libraries are getting away from collecting the bound versions because people like to go online. I'm going back even further in history, and again, you may encounter this at some point. Going back to our handout, our walkthrough handout rather, if you turn to page 17. Anybody encounter a case where the citation was a name of somebody? Sounds like kind of a last name. Maybe, maybe not. These are called nominative reporters. Way back. In the beginning of time, literally, or the beginning of the country, case reports were produced by people, usually men, who would sit in the court and take notes. And then they'd publish their notes and sell them so attorneys could see what the cases were so they could cite to precedent. And so, these men, guys mostly, not mostly, entirely, put their name on the reporter. So you will occasionally, in old Supreme Court cases, see references, especially citations in older cases. You will actually see citations to Dallas, Cranch, Wheaton. They got transferred into the good old United States Reports, so I actually brought up Volume 1, the very first volume of United States Reports, and Volume 8, just because it has a different name, and you can actually see on the spine the different names. Again, just if you run across a citation with a name, you'll know probably really old case, and you'll know what it is, and hopefully in the parenthetical at least give you a clue as to what state, federal. A lot of times, again, they will give you both the old citation, the nominative with the name, and the new citation, the standard system that we use now, U.S. for U.S. reports. And if you turn the page, you will see, as in New York, we always have to do things more complicated. You can see just all the different names in New York and how all that works on pages 18 and 19. And I'll pass along a couple of volumes of the old New York reports with the different names, Sickles and Hand, on these particular volumes, and you can see the list. And again, the Blue Book's pretty good about cluing you in as to what the names are and where they wound up in the current series, rather than these nominative named series. Any questions about nominative reporters? Okay. There are also specialized reporters. We probably encountered citations to a couple of them in our investigation of our liability questions. So I'm going to pull up. There's FRD. Anybody know what FRD stands for? Federal Rules Decisions. This actually is one of the specialized reporters you will probably encounter if you're doing any kind of litigation type work and involved at all in federal issues, but maybe not even necessarily involved in federal issues. Federal Rules Decisions. What West, the publisher of the Federal Supplement, decided to do is there's so many cases about the Federal Rules of Civil Procedure, right? I mean, that makes sense. They decided to take many of them out of that FSUP, because it just would have made FSUP even more voluminous than it already is, and put them in a specialized reporter called FRD, Federal Rules Decisions. So here you can see a case from Federal Rules Decision, not particularly relevant to anything we're talking about, but this is in that reporter. And that reporter continues to exist and continues to use that abbreviation. Again, key to understand those abbreviations. Another abbreviation some of you may encounter is BR. Anybody know what BR? Bankruptcy. I think a couple of you mentioned you might be interested in that area of law. So good to know about. And then there are a number of other specialized reporters that are basically topical, specialized, kind of the same thing, right? And I will pull up one on Lexis so you can get a sense of what the citation is going to look like. This is a U.S. Supreme Court case, as you can tell by the site. Is it working? So you see one of these string sites. So this is in a whole bunch of places. So obviously U.S. Supreme Court is going to be in all three U.S. Supreme Court reporters. It's got its Lexis site. By the way, when you do see a Lexis or a Westlaw site, it doesn't mean that it's unreported, because if you've got a reported case, it just means that that's the site that Lexis originally gave it before it made it in to the reporters. Remember, we saw that very current FSUP site from February 2017. That will always keep that Lexis or Westlaw citation, but it then will also get its reported case citation. So don't get confused by that. So here's one, USPO, 2D, BNA. So these are various specialized reporters. So BNA, you should recognize that as one of the secondary sources we looked at, but BNA also publishes the U.S. Patent Quarterly. Actually, that's not an O, that's a Q. So U.S. Patent Quarterly is obviously a patent case reporter. U.S. Law Week is another place to find very Supreme Court cases, actually sometimes lower court federal cases as well. There's the California Daily Opinion Service. And then there's a Daily Journal DAR. I don't know what that stands for, honestly. And then the Florida Law Weekly Federal. So cases can appear in a bunch of different places. These specialized topical reporters will actually be looking at some of them. Sometimes some of the loose leaf services. Remember, we talked briefly about loose leaves when we talked about secondary sources. Loose leaves do a whole bunch of things, and we'll be talking more about loose leaves later on in the semester. But one of the things loose leaves sometimes do, published cases. Sometimes they publish cases that don't wind up in the official reporters. Again, because lawyers just are dying to find that perfect case, and even if it's unreported, they could still say to a court, hey, we know this is unreported, so it's not authority, but hopefully it's persuasive. Now, obviously, you're not going to write that in a memo or brief, but that's why you're using it, essentially. But you can say, hey, here's a case, and here's a court that decided the way I think you should decide. So that's basically the reason why all these unreported cases exist. The other thing to point out, so here we see Florida Law Weekly. State legal news often are sources for unreported or even reported cases. So we see Florida here. If we jump over to, we already are in Lexis, just go back here. Remember we talked about the New York Law Journal as being the only, being the one database that has the New York Law Journal, and we looked at the news articles as a secondary source to help explain an area of law, and sometimes those articles can actually be really helpful, especially, obviously, for New York issues. Sometimes it's not so much. The New York Law Journal also publishes cases. It sometimes reports on cases that will ultimately be reported, but it also publishes and is one of the standard sources, actually, in New York for unreported cases. So we take a look. There are any number of ways to get there on Lexis. You could just type in New York Law Journal, but I want to show you the information on it because I think it will be useful. So under cases, I'm going to go to New York State Cases Combined. And notice what we see. If we search New York cases, we see lower courts trial orders. We see trial orders from New York Law Journal ALM. So just searching for New York cases on Lexis will get some of these New York Law Journal cases that are either reported or unreported. So you can see what one of those looks like. Do our favorite search by 30HMO. Now, of course, I'm searching from all of New York cases. Not too many reasons why you would want to limit the way I am about to. But I'm going to go to New York lower courts from ALM Law Journal. ALM is the publisher of the New York Law Journal. So you will, if you are a litigator in New York, it's very likely at some point you will certainly see a cite to a New York Law Journal case, and very possibly cite to one yourself. And for now, the place to find that is also the New York Journal website, but probably the better place to research them and find them, I think, are on Lexis for now. And I say for now because the New York Law Journal keeps on switching back and forth between whether it's exclusively on one or exclusively on the other. Who knows, maybe someday it'll decide to be on both. No way of telling. So for now, it's Lexis. So this basically looks like a case, but you'll see this again, the citation pretty much tells you New York Law Journal. Okay. Last but not least, and as a transition, let's take a look at a case. And just pull up a site. Because as we start to talk about researching cases and advanced tools for researching cases, it will be useful to understand what the different parts of a case are. So you may remember we talked about the parts of secondary sources, especially with regard to law review articles. So there is the title. And sometimes just searching the title of a law review article is kind of useful if we were getting way too many irrelevant results with regular keyword search. We narrowed in, focused in on the title, and sometimes that pulled up relevant articles. So We won't be searching the title of the case, obviously, because the name of the case isn't going to tell us much about the case. But we might search other parts that are useful. And I like to pull up this case in a small part because it's kind of funny, in my opinion. But also it's a nice way to show you the different parts of a case. So it's kind of funny as you may look at it. You might notice that it is in verse. A wayward Chevy struck a tree whose owner sued defendants 3. He sued car's owner, driver 2, and insurer for what was due. I'm not going to read any more of it. You can do that on your own. Fisher v. Lowe, if you're that interested. So this is the summary or syllabus of the case. West essentially gives us an introduction. And then we have headnotes. And we are going to be talking a whole lot about these headnotes in just a little while. What was kind of fun, too, is that the headnote writer, and the headnote writer is at a editor at the West Publishing Company, now Thomson Reuters, because they got bought out, and the headnote writer saw that actually that this was in verse, and so the headnote writer wrote the headnotes in verse. Defendant Chevy struck a tree. There was no liability. The no-fault act comes into play as owner and the driver say. And again, I won't read any more. And what's kind of funny about so the headnote writer at West Publishing decided to have fun with this too. Long time ago, I had the opportunity to visit the West Publishing headquarters out in Minnesota, and there's a bunch of librarians, and we were sitting around in the room with these headnote writers, and librarians were asking questions because that's what we always do. And one of the librarians said, "Oh, hey, so who are the editors who wrote those great headnotes in verse?" And the fellow who was doing the heading of the session was very serious and said, "That wasn't supposed to happen. That person was informed that that shouldn't happen again." And we were all horrified. Like, this is hysterical. We thought this was great. You guys are all so serious saying you shouldn't do that. Anyway, totally irrelevant, but I thought kind of fun. And the reason that these West editors were so inspired to write the headnotes in verse is because the judge wrote the opinion in verse. Why the judge wrote the opinion in verse, I have no idea, but that's kind of how it got started. And so the judge wrote in the opinion, "We thought that we would never see a suit to compensate a tree. A suit whose claim in tort is pressed upon a mangled tree's behest." So anyway, there are people with sense of humor in the law. Makes me feel better. Anyway, so we've got the opinion, we've got the headnotes, we have the syllabus or summary. Not in this opinion you might find dissenting or concurring opinions. These are all different parts of the case that will come in handy to know about and understand as we look into advanced techniques. Any questions? Okay, we're going to start on thinking about these strategies and then take a break, and then we will dive into the Westlaw key numbers and Lexis headnotes. So just to give you an overall start, so what I'm not, obviously, one strategy for finding cases is a keyword search. I'm guessing you all have done plenty of that for case searching, am I right? Okay, so we've talked about strategies for keyword searching in terms of connectors and plain languages and the strengths and weaknesses and so forth. So I'm not going to spend a whole lot of time going over that, although what I am going to once again illustrate on Google, actually, because Google is known for its plain language, amazing search capabilities, and I agree with that entirely. As I think I have referred, and if not, I will state it explicitly, we looked at Google Scholar. Remember, just Google Google Scholar to get here, and we looked at the articles when we talked about law review articles. Google Scholar also has case law, and search Google Scholar case law. You just choose that radio button, obviously. You can select your course on Google Scholar. So I am choosing to select New Jersey, and you'll see why in a moment, but obviously search whatever jurisdiction you are interested in. So I'm going to go for this very first search. It's typed in for me. Drunk bicycle. Those of you, actually I think all of you, were in the Foundations series last year. So Dean Selby used this example. And I was sitting in one of the sessions with her, and she was talking, this was one of the hypotheticals she used about drunk bicycling. And apparently in New Jersey, the State v. Johnson case is the leading case on this particular issue. And I'm taking Dean Selby's word for that. I'm sure you all can too. But in one of the sessions, there was a lot going on, and so what Dean Selby typed in was drinking bicycle. Now, right from our human perspective, if you're drunk on a bicycle or you're drinking and then got on a bicycle, same concept, right? Pretty much. However, even Google doesn't understand that concept. So we no longer see State v. Johnson in our top results. I think you have to go to the next page or two before you get there. So even the form of the verb, drunk versus drinking, makes a difference. So in your keyword searching, whether it's on Google, fabulous plain language, Westlaw, pretty good plain language, Lexis, maybe not as good plain language, but still not bad. Again, the keyword searching isn't always going to be pull up the relevant results. And so that's kind of my introduction, not kind of, that is my introduction to why some of these other tools that we're going to talk about might be useful. Hey, keyword searching, if you go on Google Scholar, you search cases and you find useful cases and it's a quick and dirty search, more power to you, and that does happen and that's fine. But it may not always happen. So then you want these other strategies. And what these other strategies are, pretty much, are what I call topical strategies. Using the arrangement of the resource, that bibliographic awareness, using that arrangement of the resource by topic of the case, the area of law that the case discusses, to find other cases on that particular area of law. Sometimes referred to by librarians as the one good case approach, because if you find one good case, you can find others. I kind of think of it more as the one relevant case approach, because the case doesn't have to be perfectly on point. So don't get caught in that mindset, because then you'll have a harder time. If it is a relevant case, relevant to your issue, maybe it doesn't discuss your facts perfectly, or maybe it's related to your issue, but still pretty good, you can use these topical approaches. But the thing is, if you're going to use this topical one relevant case approach, you need to start with a case, right? So what are some of the ways we've already talked about to start with a case? Or to find the case to start with, better put. Look at your syllabus and see, yeah. Secondary sources, yeah, absolutely. What else? You just do an assignment. Not the legislative history.
Find the statute, then citing references.
Citing references and
Notes to decisions.
Notes to decisions. So other ways of finding that relevant case. I was just talking about keyword searching, whether on Google or Westlaw or even Bloomberg. Keyword searching to get you started to find that one relevant case also works. And whether that keyword searching is plain language, terms and connectors. So, taking my own advice, whoops. Back here on Google Scholar, I am going to clear my selection. And that's the nice thing about Google Scholar, obviously, since it's free, not a bad place to start. So, if we want to do want to find one good case. Now, the one thing I should note about Google Scholar, not a bad place to start, but again, bibliographic awareness. Understand, if you are searching Google Scholar for cases, what you are searching and what you are not searching. Google Scholar doesn't go back as far in terms of cases covered as does Lexis and Westlaw. Now, yes, more recent cases can be more authoritative, but if your controlling case is from 1886,